Hello, everyone, and welcome to a webinar covering the new release of the National Data Privacy Agreement, version 2. Today, I'm joined by two of my colleagues. Mark, why don't you go ahead and introduce yourself?
Hello, everyone. My name is Mark Williams, and I'm a partner in the law firm of Fagan, Friedman, and Fullfrost. And my practice is dedicated to technology and technology procurement. I'm out here in California.
And I'm Steve Setzer. I'm the CEO of LoopData, which is an education technology provider. And I'm also an attorney with a background in privacy law.
And I'm Jim Siegl. I'm a technologist with the Future of Privacy Forum, a DC-based global think tank on data privacy.
So today, we're going to follow the agenda as outlined. It's important that everyone understand our approval and development process for how we came to this new version of the data privacy agreement. There are some key changes we want everyone to understand. We'll be talking about updates to the usage guideline, and then rollout and next steps for school districts, state alliances, and vendors. So the first thing to understand is that there's a comprehensive process for updating and reviewing the National Data Privacy Agreement and changes proposed to it. There are two project teams, one representing vendors and one representing our state level alliances. And those are the ongoing entities to receive questions and suggestions. We want to hear from you about things that you think would improve the NDPA. The legal project team is where those teams come together along with other interested parties to manage the development and policy and draft new versions. Every few years, a new version, a new major version is released. However, that legal project team does not have final authority. It must be voted on by the North American leadership group of the Access for Learning community after it's gone through a thorough community review. For example, the version that we're talking about today, NDPA version 2, went through at least 2 comprehensive community reviews and then was reviewed and voted on by the North American Leadership Group. We want to emphasize that even though there's a release artifact now, any community member can provide feedback. So when we got to this process directly, we started with NDPA version 1 from a few years ago. Each team separately reviewed that document with stakeholders. We gathered a large number of comments from vendors on my side and from alliance members on the side represented by Mark. We reviewed the draft section by section, collected comments on it, and then brought those together in the legal project team with a subset of the people from the two vendor and alliance project teams working together on the legal project team, along with other interested parties. That was then submitted to the North American Leadership Group, represented here as the management board for this purpose. The board has to vote to review the draft for comment. So if they had not been happy with it, it wouldn't have even gone out to community review. Fortunately, they did allow it to go out to community review. We went through 2 complete cycles. And then those changes were brought back to the legal project team. We reviewed every single suggestion, every word that was submitted by a community member. We didn't accept all of them, and some of them we accepted differently than the original author had proposed, but we did listen to all the feedback and try to address it within the framework of the laws and the purposes of this contract.
Steve?
Yes.
I just want to underline and amplify your comment on that, and that is, I can't emphasize enough how much time was spent on this. We had, Steve, Jim, and a lot of other people, and I would estimate that in totality it was hundreds of hours of review with producing, 100-page note documents. And so this was a painstaking and meticulous process.
I would agree with that. And I would add that not all of the reviewers were attorneys, that in fact, a lot of them were practitioners, people who work in purchasing, people who work in management at vendors, people representing districts. So we want to make this usable for everyone, not just a dead document that lawyers review. After release, the policy, procedure, and usage guide will be made available to all members along with the template. And the Alliance project team tends to go on during that time, helping alliances implement it. And similarly, the vendor project team helps vendors implement it and adapt to the different changes that different alliances bring to it. Let's go to the next slide, please, Jim. So there are some structural changes before we even get to specific legal language changes. A lot of these were proposed by the vendor group to try to make the organization of the document make more sense and allow different practitioners to find exactly the parts they needed. We consolidated contacts and signatures to the preamble of the document, as well as some to Exhibit E, which is where the document can be shared with other districts, LEAs as we call them. The standard clauses are almost completely unchanged. They're Articles 1 through 5 in the new agreement, and pieces that didn't really belong in the standard clauses were moved mostly to the contract terms. So the standard clauses are about data privacy, student data privacy. The contract terms are the typical terms that you would see in any agreement. How does it terminate? How does it relate to other agreements between the parties? What's the governing law, and so on? What happens when, for example, a vendor provider is acquired by another company? And then we have the exhibits. I want to emphasize that the exhibits are incorporated into the document. They're considered contractually binding. They're not examples or optional. They are a critical component of the way this NDPA works and the way its predecessor worked. We did make changes to Exhibit A and Exhibit B, particularly in the areas of how those can be updated to meet the way that vendors and districts actually work with products without requiring a new execution of an agreement every time a change had to be made. We expanded and rewrote many of the definitions, added new definitions in Exhibit C, and we've added an optional usage cover page. Any member may choose to use a cover page or adapt it and send it out to their constituents. It's useful for helping people find their way through the document, but it's not required. But all of these changes were primarily, not all the structural changes were primarily to make it easier to use. Now that brings us to another change that's a little bit closer to what we previously had, but is still a little different. We have a standard version of the NDPA. All modifications to the standard clause set, that is Articles 1 through 5, must be described and included in Exhibit H to continue to use the official NDPA moniker. So you can make a change to the contract, but it must be documented in Exhibit H. And if you do make a change to it, then it must be referred to as either a vendor-specific or district-modified NDPA. And the usage guidelines give rules on how to determine which of those applies. Exhibit H can contain modifications proposed by the vendor, the district, or negotiated between the two of them, as long as it represents the agreement of those two parties. Let's go on to the next slide, Jim.
Thank you. So as Steve mentioned, the standard clauses are where we deal with privacy. And while most of the standard clauses remained at the high level, there were a lot of work that was put into cleaning up and clarifying and consolidating the language. We dealt with changes around contract terms and termination. So the previous NDPA had a term, and this had a certain amount of challenges. One of the biggest changes was in this version, the data protection agreement stays in force for as long as the provider has the data. You can imagine this makes perfect sense. You want to have the protection of the DPA for as long as the provider has the data. So there is no longer a specific term. One of the more challenging pieces in the questions that we got asked were around security audits. So we added and clarified language around security audits. We had a fair amount of feedback in the previous language around security audits. It was not something that most districts had the capability or the affordance of being able to do their own security audits. So we looked for some kind of equivalent assurance for that security audit guidance. We also made some additional clarification around data security. Steve or Mark, did you have a comment on the security audit piece? I hear you.
Yeah, I'm so sorry. I should have waited for a pause there, Jim. No, I just want to amplify your comments on the security audits. Under the old language, we had a kind of old-fashioned accounting audit language where, it was envisioned people would actually go onto site and intrusively look at the methods of the technology provider. Everyone knew that wasn't going to happen. Districts didn't have that resources, and vendors recoiled at the intrusiveness of the language. So this has sort of turned a lose-lose provision into a win-win provision, at least in my estimation.
Great, thank you for that. One of the other things that was added was around data security. And I don't think anyone would be surprised that in the time since version 1 of the NDPA, one of the most significant changes in the K-12 space has been around the threat area of data security. So what was previously optional in the exhibit was the requirement to implement and list an adequate cybersecurity framework. This is now a requirement to describe and list a recognized standard for cybersecurity. Some other additional changes, and folks on the call that worked with me over the last year and a half know that I do have a favorite clause, and it's section 441. There were many places in NDPA 1.0 where we talked about restrictions around the vendor's ability to redisclose student data. We brought those all together in section 4.4, and we really added a number of key provisions to address some of the things that were absent in the previous NDPA. For example, a vendor might receive a court order to disclose student data, but the previous NDPA did not account for the fact that FERPA has some very specific requirements for schools when that happens. So parents have a right to be notified of that court order so they can have the ability to contest it. We put in language strengthening and requiring vendors to provide information to the schools so that parents can exercise their rights and that the school can notify the parents. Also, in dealing with the disclosures in order to protect the safety of users or others. Now, as you may know, in FERPA, there is a specific requirement called the health and safety emergency exception, and schools have particular requirements that they have in terms of recording and the authority to declare a health and safety emergency. So we added language to clarify how the NDPA should work under these kinds of disclosures. We updated the usage guidance to account for some of these significant both content and structural changes. And that is provided along with the model clauses in the NDPA. We made some changes to Exhibit A that lists products and services. So the intent in Product A is to provide the list of all of the products and services. So in Exhibit A, in NDPA2, a vendor can't make any changes to Exhibit A via an addendum, except for adding or deleting products and services. And we'll talk a little bit about how that works in terms of the data field and Appendix B. I wanted to pause for a second because I know Steve and Mark, we both spent a lot of time talking about Exhibit A, and wanted to ask if you had anything that you wanted to add that I may have missed in terms of Exhibit A before we move on.
I would like to. One of the things that this allows for is this allows for vendors that have a large number of products to list them all and to list and to place them all under data protection, even if the LEA hasn't currently purchased them. Obviously, if an LEA has not purchased a product, then they don't have data in it, and so there won't be any necessity for protection for it. But this allows that at any time in the future, through negotiation between the LEA and the provider, new products can be obtained and they will not have to negotiate a new agreement. This takes a big burden off both sides. The addendum concept, which is in Appendix, and I need to emphasize Appendix B, not Exhibit B. The addendum concept allows a provider to make changes to Exhibit A and with approval to Exhibit B within the structure allowed here. For example, an Exhibit A can only add or remove products and services. It can't change the nature of the way those are protected. We also have those changes flow down under specified conditions. And all of this to allow things to be more broadly accessible. There were some things about Exhibit A and Exhibit B that tended to get very LEA vendor contract specific. And we wanted to make it easier for both sides to apply the same rules everywhere.
You know, just to follow up, Steve, on some of your comments, it's interesting to me, of all the documents that have evolved the most, that is Exhibit A. Originally, Exhibit A was product specific, and it contented itself with describing what the product actually did. But as this agreement became in wider and wider use, we needed to scale up and include more products and include more choices for LEAs. And in order to do that, we needed to change the nature of Exhibit A to be more of an inventory of products that were to be employed. And that allowed better penetration of products, better choices for local school districts and other LEAs. In Exhibit B, we went from just a simple checklist of data to a schedule of data to encompass a range of products. So the nature of both have changed, and I think it's a reflective of the success of the agreement itself.
And I think in terms of Exhibit B, one of the other pieces that is interesting about Exhibit B is that Exhibit B is no longer unique for the LEA. It is broad across the DPA, so it applies to all subscribing LEAs. In terms of updating the Exhibit B, the vendor needs to notify the LEA of an addendum that modifies the schedule of data. And the LEA is going to have 30 days to object to any changes on the addendum before the addendum becomes incorporated into the DPA as an update.
Hey, Jim, can I ask you a clarifying question there?
Yep.
and this is for me and perhaps other users out there, when they're going to change the data that's required, is that addendum loaded up into the registry itself? Do you follow my question?
Yes, it is.
Yes.
It is, okay.
Yeah, the registry team, I don't know if they have all the changes in necessary for that functionality, but that is being worked on, and some of the changes are already in.
Gotcha.
No, great question.
So can I just comment a little more on Exhibit B, Jim?
Please do.
So with this part where the Exhibit B is no longer unique for the LEA, some LEAs may only use a subset and may only send the provider a subset of the data that the Exhibit B covers. Formerly, when Exhibit B was individually allowed, some LEAs used their Exhibit B as a source for their reporting requirements to parents. This is no longer possible, because now what you're getting in the Exhibit B is the universe of data that might go to that system. And if you as an LEA are only sending a subset, then that subset is what you need to disclose to your parents and stakeholders. But what that does allow is for, again, the LEA to expand the scope of their usage and the scope of their data without having to go back and file a new NDPA. Another note on scheduled data is that that has implications for Exhibit E subscribers, which we'll talk about when we get to Exhibit E.
So when we think about our next two exhibits, C and D, a number of additions in terms of the definitions. We've looked at change of control. We have a new definition for contextual advertising and clarifications for things like de-identified data. Steve, we had a lot of conversations about the term service agreement, and I wanted to pause here before we move on to Exhibit E and ask if you or Mark have anything you want to add on the conversation around the changes on and enhancements on definitions.
Just to kind of set the stage, and maybe Steve, you can build on this. One of the challenges of the definition section, at least originally and later as it evolved, is different statutes refer to student data in different ways, and different statutes refer to advertising and what is contextual advertising in different ways. So and unfortunately in the earlier versions, Exhibit C, the definition section, kind of reflected the diversity, but also produced the same perplexity in users of this agreement. And I think Jim and Steve did a great job at bringing in a unifying lens so that the terminology would sweep across the agreement in a coherent manner.
I think that's a good point, Mark, and Jim highlighted the service agreement definition. There's always been questions as to words like the agreement versus the service agreement, what's incorporated in each of them. We think we've clarified that in the new definitions, and trying to say when a requirement is part of the NDPA versus when it may be a part of your sales contract, license agreement, or other contract between provider and LEA. I want to skip down to Exhibit D because that's one that I'm pretty excited about, actually. Exhibit D itself hasn't had a lot of change, but the biggest change, I think, is the clarifying language that if the LEA has special requirements for the disposition of student data that are not expressed in 4.6, disposition of data, the LEA may fill in this form. So previously, Exhibit D was presented as kind of the only way for an LEA to tell a provider to be done with the data. Section 4.6 is rewritten and takes into account both modern practice among vendors as to data retention, data policies, all the legal requirements that are placed on them by other entities. And also it takes into account the new term and termination clause, where as long as the provider holds the data, that's how long the contract is in effect. So basically, there's a set of default rules in 4.6 that reflect modern practice and should be sufficient for most cases. If an LEA has some special requirements that aren't expressed in those, maybe they're policy requirements or maybe they're local legal requirements, then Exhibit D is for documenting and directing those special requirements. We do want to have the provider include their standard destruction schedule, and we wanted to include methods for how to certify if the data is being de-identified rather than destroyed. What does that mean, and how do we proceed there?
I think there are a number of benefits to this change. One of them is really a lot of times the form was really used on contract termination. So in terms of good data hygiene and limited data retention, this really allows vendors to have kind of a standard process or to document the way that they handle data deletion, for example, on things like end of year rollover. So I think this is a really useful change. We mentioned briefly some of the changes on a requirement for identifying a cybersecurity framework. Before we move on to the last two exhibits, there were relatively few changes to Exhibit E, but I wanted to pause and see if there was anything specific, either Steve or Mark, that you wanted to call out about Exhibit E before we move on.
I think I foreshadowed one earlier. So Exhibit E is the exhibit that allows the terms of a signed DPA to be used by another LEA. And we hammered through multiple times, clarifying the language around the subscribing LEA and the originating LEA. We consolidated the contact information for subscribing LEAs to better mirror what's up front for the original. And we documented the effects of Exhibit A and Exhibit B changes. If a vendor makes a change to those using the addendum process, then Exhibit E talks about how do those changes flow down to the subscribing LEAs, what sort of notice do they get, when do they get it. And so we tried to take the significant changes we had put in the main agreement and make sure that Exhibit E brought those benefits to our subscribing LEAs.
I think that covered the Exhibit E very well, Steve.
Before we go on, I want to emphasize one other thing. We expanded the definition of LEA. So LEA generally means what the Department of Education means by it, which is a local education agency, aka a school district or an independent charter school. But it's such a commonly used term throughout the contract. And there were so many uses for regional service centers and even private schools and individual schools, the state agencies, all kinds of places that could be using this agreement. So LEA means the educational entity that is contracting with a provider. And it's a much broader definition than you're used to in legalese.
With LEAs in mind, thinking about LEAs and SEAs are really kind of a focus on the next two exhibits, G and H. Mark, why don't you take us through some of the major changes to G and H?
Sure, and let me set the stage for discussion of the two exhibits. probably the most important issue in any drafter of a uniform data privacy agreement is the inherent conflict between customization, the need to mold the agreement to the particular circumstances and preferences of the LEA and the vendor, and the need to avoid fragmentation. Because if at some point when you're customizing, the rubber band breaks and you have a proliferation of agreements that are no longer by their nature uniform. So our most important task, in my view, in maintaining the integrity of the agreement and this entire process is to find that balance between needed customization without breaking down into fragmentation. So Exhibit G and Exhibit H are separate exhibits, but they're interrelated in some profound ways. So the state supplement is set out in Exhibit G, and it reflects the varying statutory requirements by state, and quite frankly, in some cases, the preferences of state associations. So the state supplement is an optional set of terms that will be generated on an as-needed basis to meet state-specific data privacy statute requirements. The scope of these state supplements will be to cite and address any state-specific privacy statutes and their requirements to the extent that they require terms in addition to or different from the national standard clauses. So the thing to keep in mind and keep this firmly in mind is Exhibit G is state-derived changes or suggested changes or modifications to the underlying agreement. If you're going to a more micro level and you're addressing it at a Exhibit H, that has more to do with LEA or vendor-specific changes to the document. And so that's an entirely different set. And from my view, and Jim and Steve, feel free to jump in here, to me, the part to be wary about in terms of exhibit, in my mind, is Exhibit H. That's where you have to pay particular attention to what is found in Exhibit H. Okay, do you want to move to Exhibit H?
Yep.
Oh, okay. We had a lot of discussion about how Exhibit H should be used. Recall that the agreement as a whole already encompasses a great deal of flexibility. You know, it has a great deal of flexibility in the security framework. It has a great deal of flexibility in the data elements involved. It has a number of different options. Exhibit H is an option in its entirety. So, and we're aware of that an overuse of it could be damaging to the process, but we didn't want to be patronizing about it. So if there's a valid concern, we didn't want to foreclose that option. So we spent a lot of time, and you could talk to Jim and Steve sometime about how much time we spent on this, but what is that fine line? So the result that we came up with is that Exhibit H is not included in the standard NDPA and is contained in the district modified and vendor specific versions, which are, Jim, to my understanding, are separate agreements or separate faceplates. Am I stating that correctly?
Correct.
Okay, so any changes to Exhibit G, and these, you know, we can look at these rules and just pay particular attention to them. Any changes to Exhibit G negotiated between vendor and the LEA must be identified in Exhibit H. Exhibit H can also be used to display simple copies of minimum changes or an entire red line of the DPA. So as it turns out, Jim, tell me if I've got this correctly, because this is a nuance that I know was a long time coming. If there are red lines in the main text, there's two ways to do this, folks. One is you put the changes in the exhibit, or you can put it into the document itself. But if you're putting it into the document itself, you have to replicate it or duplicate it into the exhibit as well. Did I say that correctly, Jim?
Yeah, so I think the last bullet on the slide really kind of captures it, is that the body of the text, the clauses are unchangeable, and all the changes go in Exhibit H. So it's just a matter of drafting preference. Some folks might just want to put the changes, what parts have changed, and that's what's in Exhibit H. Some folks might want to see the entire red line in context. And since you're not going to be marking up the body of the standard clauses are kind of inviolate, they're unchanging. They would put the entire document into Exhibit H and redline it there. So none of the changes are in the body of the document. All the changes are going to be in Exhibit H. And it's really just, do you want to include just the changes, just the top line, what's changed, or do you include the entire text of the clauses and basically use a red line? And I think it's really kind of a matter of drafter preference. So we can see the way that district would use Exhibit H in a couple different examples that you alluded to. So if you want to kind of talk through some more of these examples we've got up here in terms of the standard agreement is the unmodified agreement, and Exhibit E is automatically part of that agreement and active. And then we have two variations depending on who's modifying them. Is it the vendor that's modifying them as in Exhibit H, or is it the district that's modifying in Exhibit H? Mark, Steve, I'll start with you, Mark. See if there's anything you want to add to the examples, and then we'll turn to Steve for anything to add before we go to the details on naming conventions.
Just this, and that is, and again, I'm speaking with a broad stroke here. The standard agreement, if you want to look at levels of complexity and ease of use, the standard agreement where there isn't an Exhibit H is for the acquiring school district and the administration by the vendor, by far the easiest one to use. And Steve and Jim may have different opinions than mine. My strong preference is use the standard agreement. If you get to the vendor-specific NDPA or the district-modified NDPA, you're entering into more precision, but it's harder to use. So just keep that in mind as you go into the two variants. So in the first one, the vendor-specific NDPA, they are changes that have been approved by the Alliance, or the Alliance has made a policy decision to permit the LEA approval of Exhibit H agreed to changes. So an Exhibit E would be permitted because you, correct me if I'm wrong here, Steve, you have the approval of the state association. So the vendor has the option to check the box and sign an Exhibit E.
Yeah, that's right. And a comment to this, well, you finish your presentation and then I'll come back. I have some comments for vendors specifically on the vendor specific NDPA.
So just real quick, just to finish up the third variant. The third variant is the Exhibit H changes are not Alliance approved or allowed by Alliance policy decisions. In that case, the agreement, if I may be use loose terms, stays local. You cannot sign the Exhibit E. And what happens in that case is that the vendor must sign individual agreements with each district, which, if you think about it, undercuts one of the primary advantages for a vendor to use the DPA in the first place.
Right. And one of the things I want to go back to the language of the NDPA version 2 itself. In many places, there were places where vendors were requesting us to adopt provisions of some state laws that are widespread or common law usage. Rather than adopt those, we took a role of not preventing. And so in my opinion, there are things that under NDPA version 1, a vendor might have put into an Exhibit H, a vendor-specific type of Exhibit H, that I think under NDPA version 2, you would want to put those in your service agreement instead. You wouldn't want to put them in Exhibit H because they would be allowed but not required by the language of NDPA version 2. There are several of these places where we simply said, if it's not forbidden or required by federal law, then you can do it. But in my opinion, and this is my opinion, not necessarily in the agreement itself, you should plan to put those in your sales terms, your purchasing contract, license agreement, whatever is allowable but is not required by the NDPA, you should keep there. And you should only do a vendor-specific NDPA if you've really got something that just needs to be a change. It's not just that it's openly allowed by NDPA, but you actually need to change something about NDPA. So be cautious of that. Look carefully through the agreement, vendors, with your attorneys, and find as many places as you can where you can fit something into that. And that will give you many more chances to use the standard agreement.
Thanks, Steve. And I think that really emphasizes the point. And what was a challenge in the previous NDPA was thinking about Exhibit H as essentially the home, the kitchen sink, the home for all possible contract and terms type clauses. And what Steve just outlined was really a framework that allows the DPA to be about data privacy and pushing those other more contract terms to service agreements. So when you use a vendor specific or a district modified, just to keep it straight from the standard agreement, we have some housekeeping in terms of naming conventions for working with the registry. The registry automatically names the agreements as it's uploaded, and if changes have been made to the DPA, will be an option to select either vendor specific or district modified, just to keep it clarified that it's not the standard agreement. And we have a naming convention in terms of adding state abbreviations and version numbers and agreement types that's required. And so I think this is a housekeeping piece that makes it a lot easier, because often when I was in my district, I found it very useful to look and see what agreements other states, other districts had, and knowing it's much more useful to be able to look for that standard agreement that's not district specific.
Can I call out something, Jim? Can I call out the last bullet on this page?
Yep, let me jump back.
Okay, my screen hasn't updated yet.
Yep.
But if you make a modification to the standard clause set, and it's not documented in Exhibit H, you may not use the name NDPA or National
Right.
Data Privacy Agreement. That is intellectual property, and the entire agreement is intellectual property, and you're licensed to use it under terms. You don't have to pay for it, other than your membership fee or whatever, but you are licensed to use it under certain terms, and that's one of those terms. If you make a modification that you don't tell people about in Exhibit H, that's not an NDPA, and we're going to be more. We want to hear from you when people are taking the agreement, changing it, and presenting it as if it were A4Ls, and we want to encourage you to stick within the A4L framework.
We don't want any Gucci knockoffs.
That's right. This isn't downtown Times Square.
So as part of the rollout, there were a lot of enhancements to the usage guide. So one of the things that was included was a sample cover page template. So this could be used as a cover letter for a district to their vendor, or an alliance to districts, or from the vendor side, as a way of starting the conversation around creating an instance of the NDPA for a particular vendor. The NDPA was released at the end of April of this year, and various states alliances are in the process of reviewing it and adopting it. And those are going to be alliance specific decisions. As we think about the roll-up piece, are there any, Steve and then Mark, are there any things from the vendor side and then afterwards from the district side that you want to add in terms of what vendors or districts might be or should be thinking about in terms of the NDPA rollout and this transition period?
For vendors, I'd like to remind you about the registry. If you're not using it, start using it. It's really got a lot of enhancements, and you can use NDPA, the standard version today, with any district that's not in an alliance state, or any customer that doesn't otherwise fit into an alliance. So go ahead and start using it there. Unfortunately, we are waiting on the alliances. So you may unfortunately have to go through a DPA process twice if you have a customer you're acquiring this summer. You may have to sign the old one with them now to get their data protected, and then do a replacement with them by agreement. So that there is a little extra workload this year, and I won't kid you, but it's worth it. And waiting for the alliances to get their Exhibits G fully organized and put in place is well worth your time.
And Steve, I think that just to flip that analysis, the exact same thing applies to the LEAs. I'm still getting DPA version 1s, and those are great, but version 2 is a better model. And as soon as you can get your hands on it, the better. And understand that it's going to be a little bit messy for the next 3 to 6 months as we roll this out and districts adopt it and actually put it into their inventory of forms. But that's kind of the price we pay for progress.
So we're recording this webinar in the middle of July in 2024, and we don't know what your questions are going to be about the NDPA. But as always, you can route your feedback, your constructive suggestions through your vendor working group and your alliance working group. And I'll turn it over to Steve and then to Mark for any final words.
My only final word is, if we've contradicted each other or the slides, just remember that the NDPA itself is the controlling document and the Second most authoritative document is the usage guide. We're pretty smart on these things, but we do confuse ourselves sometimes.
And I want to thank all of our users' patience in this process. It took us a long time to get through it, but the length of time guarantees a better product, and we think that you'll find its advantages to be worth the wait.
And I'll let that be the final word. And thank you everyone for your time.